There's people meeting probably right across the street right now negotiating an energy bill. A lot of you might know what's in that potential energy bill, including whoever the sponsor of the legislation is going to be. Yet the sponsors of these pieces of legislation, which have a tremendous amount of impact over the people of Illinois, have no idea who's crafted it, no idea what's in it, other than their names on the bill, and we're going to pass it. We need a new way, people. We need a new way.
Representative Windhorst.
Thank you, Mr. Speaker. Will the sponsor yield?
In case will yield.
Thank you. Representative Tarver?
Yes, sir.
These maps will apply to both the Supreme and appellate courts. Is that correct?
Yes, the appellate courts sit within the Supreme Court districts. Yes, sir.
I have a question regarding Section 35, which is entitled Current Members of the Judiciary.
Section 35?
Yes.
What page of the bill, if you don't mind?
It appears to be on page 6.
Okay, I'm on page 6.
The bottom of page 6 onto page 7, it appears.
Okay, I'm here with you.
So under the language of the bill, the current members of both the Supreme Court and the appellate court who are not up for retention will maintain their positions. Is that correct?
When you say maintain their positions, remain in their seats?
Yes.
Yes, that's correct.
If an individual is up for retention, a judge is up for retention, and their district boundaries have moved, they will have a choice on which district to run for retention. Is that accurate?
I know that that's accurate, but give me 1 second because I want to make sure that I cite it for the record, okay?
Sure.
Rep. Windhorst, I'm going to go to page 4.
Okay.
And I'm going to start at line 4 to 14. I think it answers your question, but it's probably important for the edification of everyone in the room. To ensure the continuity of service and compliance with the Illinois Constitution of 1970, nothing in this act is intended to affect the tenure of any appellate or Supreme Court judge elected or appointed prior to the effective date of this act. In accordance with the Constitution, no change in the boundaries will affect an incumbent's qualification for office or right to run for retention. I think this comes to your point. Incumbent judges have the right to run for retention in the counties comprising the district that elected the judge, or in the counties comprising the new district where the judge resides, as the judge may elect.
That's how I read it as well. And so I want to ask you about this scenario. And a judge is elected in the 4th district. With this bill becoming law, that judge now resides in what would be the 5th district. The judge is up for retention. The judge decides to run for retention in the 5th district. The judge is successful in retention. Is the judge now sitting on the 5th district or the 4th district Court of Appeals?
I'm trying to make sure I follow. So they were a Supreme Court justice in the 4th district.
Appellate court justice.
Sorry, appellate court, excuse me. They were in the 4th district. And then based on the map, they now, you said reside in the
5th district.
5th district. And they run for retention in which district?
They choose the 5th district to run for retention.
Okay. And then they would be the 5th district and a 5th district appellate court judge.
Now, there are other portions of the law in Illinois which set the number of justices in the appellate court. Does this bill change the number of appellate court justices in any of those districts?
No, not to my knowledge.
Then doesn't this create a conflict of laws in our state? It's not addressed.
Well, I would never say yes, it creates a conflict of laws. I don't believe so.
But you see where that could become a concern. So let's go through that scenario again. Person, the same 4th and 5th district, and the person wins in the 5th district, and you believe the bill says they now are a justice on the 5th district Court of Appeals, even though the 5th district never elected them, correct?
I thought you said he ran for retention.
He did run for retention, but he was not elected. He was just retained, he or she.
I'm not trying to be deceptive. I'm really trying to follow the narrative. So they were in the 4th district.
And elected.
And when they determine they want to run for retention, they now live in the
Fifth
or
district.
elect to run in the 5th district.
Correct.
And the question is, what is it? Would they be a 5th district appellate court judge or justice? Which I said, yes, I believe so. And then the issue is that, are you saying, I don't want to put words in your mouth, that there'll be too many justices on the Supreme Court?
That's issue number one. There'll be too many
Appellate court,
justices on that appellate court district. That's issue one, which I believe creates a conflict of laws. It's not addressed in this bill. Number two, the issue is that justice of the appellate court was never elected by the 5th district. They were only retained. So they never had a competitive election, which is different than a retention election. That's the second concern.
Let me ask you this, because
Yes.
I'm thinking this could balance. The Supreme Court could reassign a judge. So you're saying someone who was in the 4th district now runs in the 5th.
It runs for retention in the 5th, according to this bill.
Okay, which creates a vacancy in the 4th.
Well, that's my next question. If that occurs, does it create a vacancy in the 4th district?
Okay.
And so you will have a situation where there would be then 7 justices in the 5th District Court of Appeals, only 5 justices in the 4th District Court of Appeals.
Yeah, I follow what you're saying, but even beyond legislative intent, I can't think of a scenario in which the Illinois Supreme Court will leave a vacancy in the 4th district where they could appoint and then have extra appellate court justices in the 5th district. I understand what you're saying. I don't.
Well, I think beyond trying to decide what the Supreme Court's going to say, don't we have to craft that into this legislation to make sure it's clear what we intend when those vacancies were to occur?
No, and I certainly appreciate the opportunity to further clarify. The intent is certainly not to have the situation that you just outlined. The intent is to ensure that the 4 judicial districts outside of County of Cook are substantially equal in population, with each being compact and composed of contiguous counties. That's the legislative intent of Senate Bill 642.
Well, and I also want to be clear, this scenario, because the district lines have changed so much, is likely to play out with retention for the next 10 years, 20 years, 30 years, because so long as those justices are sitting, they will have the opportunity to make a selection on how they're going to run for retention according to this bill.
Is it right? So is the suggestion that this is interesting. So is the suggestion they should not have the opportunity to make that choice and then essentially be forced into a new district? I thought I heard pushback about that as well.
My solution is the bill needs to be clearer on that issue, because I think it's an issue that will play out. To the bill, because of this conflict of laws, putting aside which I think are major concerns with the way the districts are drawn and the data used to draw those districts, this provision in the law is going to create a conflict of laws which could result in this section being thrown out and could create further confusion on how justices will be retained going forward. So I'd encourage a no vote.
Members, we're going to institute a 5-minute timer. Representative MAZZOCHI.
Thank you, Mr. Speaker. Will the sponsor yield?
Absolutely.
On page 2, line 18, it says in this bill, it says, under this redistricting plan, the population, according to the American Community Survey of the 2nd District, will be 1,770,983. 3rd District will be 1,953,49. 4th District will be 2,011,316. And the 5th District will be 1,839,679. A similar, substantially equitable result occurs using the 2010 U.S. Census data. So if in fact this is the same similar census data that we had and population metrics we had back in around 2010, why was this not done 10 years ago?
I mean, I could ask why in 97 and 98, your party tried to divide Cook County up, which unconstitutional and tossed out of court. I wasn't here in 2010, so.
All right, well, did you even bother to find out before you put this in your resolution?
Did you bother to find out why your party tried to split the courts in Cook County and it was deemed unconstitutional?
I can absolutely, it's not unconstitutional. I can tell you the reason why, and actually I'll do that. I'll go to the bill. The reason why the people in our party are actually very concerned about the Democratic Party's efforts to manipulate the Illinois Supreme Court, as they've done in every other branch of government, is this. The Illinois Supreme Court wasn't redistricted 10 years ago, and it's only being redistricted now for a critical reason, because hundreds of thousands of people worked really hard to try to get a fair maps amendment on the ballot in Illinois. And make no mistake about it, that ballot initiative was a struggle for power. The people wanted the power back from the political insiders who refused to pass a fair maps amendment, who refused to put it on the ballot through this legislature. So they went outside this legislature to try to do something that was going to bring reform to Illinois in our elections process. Now, one of Mike Madigan's favorite lawyers challenged that ballot provision, and the fair maps went all the way up to the Illinois Supreme Court. What happened? The people of Illinois were denied their right to take their power back in a ballot initiative because of 4 votes on the Supreme Court. 3 of them were votes from Cook County justices who voted to strike it down, one of whose husbands is currently under indictment for racketeering and extortion. The other justice, the one justice who wasn't from Cook County, was Justice Thomas Kilbride. And unlike the people in Cook County, the people in Justice Kilbride's jurisdiction didn't like the fact that a judge, a Supreme Court justice, was putting his thumb on the scale for partisan Democratic Party power broker interests instead of the interests of we the people. And for the first time in recent memory, a Supreme Court justice lost his election for retention. What is the Democratic Party doing in response? Did they think maybe we should support more honest judges? Did they say maybe we should ensure that the Supreme Court justices aren't behaving like political partisans and aren't tied to the interests of political power brokers? No. For the first time in decades, you are now drawing a new Supreme Court map. With this bill, the Democratic Party is telling the people of Illinois, once again, heads they win, tails you lose. I urge a no vote.
Leader Batinick.
Thank you, Mr. Speaker. Will the sponsor yield?
Of course.
Thanks, Representative. I did not intend to speak on this bill, but one of the earlier speakers brought up a point that seemed very confusing to me and apparently confusing to you. So if this legislation were to pass, we were talking about appellate courts, how there could be an unbalance of judges running for retention. And if you draw judges in a certain way, you could have 7 appellate court justices in a district that's meant to have 6, I believe. So, okay, I see a nod of the head. Go ahead and explain it.
It's not true.
Okay, could you explain it further, please?
We're not expanding the number of judges. I mean, I don't know another way besides saying in these 9 pages or so, it clearly spells out the intent, and we're not affecting anyone's tenure. We're not adding additional justices and changing the number of the justices or appellate court judges throughout the state.
Okay, to the bill. I'm going to let the previous speakers, one of my previous representatives to my right here, his words kind of carry the day. It's clear that you're not writing this legislation, involved in this legislation. I'm not sure how much you know about this legislation. I urge a no vote.
Representative Ugasti.
Thank you, Mr. Chair. Will the sponsor yield?
Gates will yield.
Afternoon, Representative Tarver.
Good afternoon, sir.
Quick question. Would you agree with me that the judiciary is supposed to be independent of the other 2 branches of government?
Do I agree that the judicial branch is a co-equal branch of government?
No, that there's to be an independent branch of government from the other 2.
I think it's a co-equal branch, and I'm not sure I understand the question.
Well,
Maybe,
is
you want to
the
define
word
independent?
is that the term that we'd like to get around, or would
No,
you?
if you define what you mean by independent, I'd appreciate it. I've always known it to be a co-equal branch of government. That's what I was taught when I was in grammar school, law school, and otherwise. I'm not trying to avoid the word independent, although I think
Okay.
independent is loaded.
All right, well, I look at it as one that's exercising its own authority, acting under its own power and deciding things for itself. They make their own rules, correct?
They make their own rules based on what we allow them to make rules? Is that what you mean?
Well, they exist in the Constitution because a constitutional convention was called, so they decided that. I don't think we decide that for them. Is that correct?
We're going to get way afield, but are you suggesting to me the judicial branch drafted the Constitution?
Would you agree with me that they are to decide cases and questions before them fairly and equally amongst all people?
Do I agree that that's what they should do?
Yes, absolutely.
Do I agree that the court should decide cases fairly? Yes, I believe the court should decide cases fairly.
Okay.
Based on the merits, the facts, and the evidence before them. I do agree with that statement, sir.
And independent of any influence from the outside, correct?
Again, I need to understand what you mean when you say independent. I mean, there's evidence and things like that. The evidence doesn't grow within the court. It comes from somewhere. People come in and testify, right, in these courts. And I don't even know what level of court you're talking about, but in every instance, none of it is homegrown within the court itself. It all comes from somewhere. So when you say independent of outside influence, I just don't know how you define independent or outside influence.
Well, we can get around this and hash it out for a long time, and I could keep asking questions. Let me ask you this. You went through quite a bit of questioning about who did draw the map, and it seemed pretty clear you weren't certain exactly who. Can you tell me, did an independent commission draw the map you're proposing today?
I can tell you a couple of things, and thanks for asking. One, I've never heard anybody in this chamber call somebody from LRB down and ask them about having drafted a bill. So, in the same vein, not every 118 people in here draft every single bill on their own. So, I didn't draft this legislation. I did not draw the map. That's correct. As far as the commission, sorry, to answer your question.
Okay, I'm sorry. I thought you were done. I apologize.
No problem. But as far as the commission, my understanding is that there, as we've said throughout all these hearings, were staff and a team that prepared these documents as well as the map. How you define an independent commission, I'm unsure. Are you talking about the independent commission that is noted in the Illinois Constitution if we're derelict in our duty and don't pass a map? Is that the commission you're talking about?
No, it's not. To the bill.
Because we didn't get there.
To the bill.
The bill.
I find it extremely difficult to believe that a representative as smart and intelligent as I know Representative Tarver is doesn't understand what I mean when I ask about independent. I feel like I probably should have brought a dictionary today, but I didn't. This map is supposed to be about a separate branch of government, the highest level of the separate branch of government, that is to decide issues independent of outside influence. And unfortunately, this outside third branch of government that's supposed to be completely independent, that should be nonpartisan completely, is unfortunately not being drafted by an independent commission, and I believe we all know that here on this floor. I urge a no vote.
Mr. Brady.
Thank you very much, Mr. Speaker. With sponsor yield.
He indicates a yield.
Representative, many years ago, my father ran for 4th District Appellate Court, and at that time, as I remember the makeup of the 4th District, there was 30 counties, if I'm not mistaken, that were part of that 4th District. Under this new proposed map, do you know how many counties are there now? And secondly, if you do, how the formula was based on for those changes?
Well, one, the counties are listed. I got to find which page here. So if you want, I can go through and count each one of them, or we can take it as read. Let's see. Math is not great, but I count 41. Does that sound about right? Well, let me do this for the record. I'm
That's
on
okay.
page 6,
We can
starting at line 1.
Okay, we can say approximately 41 counties if that's what you come up with. So how does it go from 30 to 41? In other words, the formula, I guess, is what I'm asking.
So
What was
that's
used?
great. I'm not great at math, but when you ask about the formula, I think the formula, getting back to the intent, is to have substantially equal population. So the 4th district had 1.3 million people. The 2nd district had close to 3.2 million. The reason for the increase in counties is the shifting population and where people move, which I'm assuming there's been some movement since 1963.
So that's the math that was followed to change the districts then, correct?
The math breaks out like this, and this is my rudimentary math. District 1, 5.194675. You divide that by 3, it's about 1.7 million people. Districts 4 and 5 have 1.3 or so million people. District 2 is 3.2. District 3 is 1.8. So, again, it's rudimentary math for me, but I don't know a situation in which 3.2 and 1.3 are in any way substantially equal in population. We're talking about close to 2 million people.
So without the census data available, then this was based off county populations, an increase from the counties?
I'm sorry, is that a statement or a question?
That was a question.
And will you repeat it for me?
Sure. Since the census data was not available, the formula in which was used would be numbers based off county population?
Just because I love to have a clean record, I'm not going to agree with this whole formula thing. I'm just going to go with the rudimentary math, which is there were 3.2 million people somewhere and 1.3 in 2 other places. So 2 districts had less than 1 district by 600,000 people.
Okay. Thank you very much. To the bill, ladies and gentlemen.
The bill.
Obviously, I think it's crystal clear that the formula, or question thereof of what formula, is in doubt here, and I certainly intend to vote no. Thank you.
Representative Tarver to close.
Thank you, Mr. Speaker. Just a couple of things. One, while I appreciate it being patted on the back for being smart and all those kind of things, let's be realistic. Representative Ugaste, you graduated high school in 1981. That's the year that I was born. If my math is somewhat reasonable, you were born on or around 1963. That would have been the last time that the map had been remapped. Your fearless leader was born in 61. He was 2 years old the last time this map was remapped. Now, I'm not going to go through a poll through everybody. I think Brady was born before 63. I have a list of individuals, but you get the point. Unless all of you are going to tell me that you remained in your childhood home, you moved. You were part of populations that shifted since 1963. How is this difficult? Your fearless leader, he left home, went to Illinois State, went to John Marshall for law school. He's now in Westchester. This is not difficult. People move. When people move, you do this thing like you count them. That's what you do, because that's important. And to have districts that have 60% less than other districts are not substantially equal in population. Not a very difficult thing to understand unless you don't want to understand it. I get your point. You want to bring up a justice loss, all these different things. This is about the Illinois Constitution. That's it. It requires substantially equal population. And if anybody wants to suggest that when 2 districts combined, I don't care how many counties, have less than 600,000 less than 1 district, that's substantially equal. I don't know, the word of the day has been astounding. I guess I've just found that asinine. It's been nearly 60 years. People have moved. No one's in their childhood home. They've contributed to the moving. You move to these counties. They now need to be remapped so that everybody has an opportunity to elect Supreme Court justices where they live in a fair manner. Because what I do agree with is that there's 3 branches of government, and 2 of them, or all 3, we can elect people. Everyone should have that ability to do so. So, I appreciate the banter. I appreciate the back and forth. I appreciate the pat on the back for being smart, I guess. I urge a yes vote, because this is just simply trying to make sure that everyone has the ability to participate in the judicial system as apparently contemplated by part of the judicial branch at the Constitutional Convention. Not difficult. I urge a yes vote.
The question is, shall Senate Bill 642 pass? All in favor vote aye, all opposed nay. The voting is open. Have all voted wish? Have all voted wish? Have all voted wish? Mr. Clerk, please take the record. On this question, there are 72 voting yes, 45 voting no, 0 voting present, and this bill, having received a constitutional majority, is hereby declared passed.
Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.